Can New York State decide to start charging employees to take civil service exams? To find out, you have to read New York versus PERB. It's only 6 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on New York versus the New York State Public Employment Relations Board. This can be found at 2023 New York Slip Opinion 00805, published by the Court of Appeals on February 14th, 2023. This is a civil case, an employment law matter. The issue in this case is whether waived fees for civil service exams are considered terms and conditions of employment under the Taylor law. And I'm going to explain all that in a minute. The law you have to understand this case is, first you have to understand the Taylor law. The Taylor law is essentially a statutory presumption that all the terms and conditions of employment between a public employer and the public employees should be collectively bargained. And this is an attempt to avoid strikes. It's an attempt to avoid litigation in court, that basically everything should be collectively bargained if it relates to the terms and conditions of employment. You also have to understand that civil service law, New York State Civil Service Law, Section 50 talks about civil service examinations. So there are a lot of jobs in the state of New York that you can only get by taking the civil service examination. And there are also jobs that you need to, there are also jobs involving promotions, like higher level jobs in the system, that you have to take promotional exams, which are also defined and described under Civil Service Law, Section 50. Now, the thing about Civil Service Law, Section 50, sub 5, is it states that every applicant for an examination to take a civil service law, to take a civil service examination, has to pay a fee. Okay? But even though it says every applicant has to pay a fee, it says nonetheless, that fee can be waived for certain classes of people. And the statute specifically waives it for people who are on public assistance or veterans who are looking to get their original appointment. Now let's talk about the facts. The facts here are that from 1999 to 2009, the Department of Civil Service waived those civil service examination fees for employees of several organizations who basically are the plaintiffs in this case. And the organizations include the CSCA, the local 1000, the AFL-CIO, Police Benevolent Association, corrections officers. There are a variety of organizations, public service organizations, public employees who receive this dispensation, this waiver of the required fee. But in 2009, the Department of Civil Service stopped doing that. They stopped waiving the fees. They started assessing the fees on people who were in the system, in these groups, to take civil service exams. DCS did not ask permission for this. They didn't collectively bargain it. So when this happened, the plaintiffs, who are these organizations, organizations of public employees, sued, saying that New York State violated that Taylor law because they didn't collectively bargain this issue of fees, and that they had bound themselves to this practice of waiving the fees by their past practice. It goes to the Public Employment Relations Board, and they say this was a term and condition of employment because it was an economic benefit, and they say that they throw it out. And the state then appeals and goes to the appellate division, and the appellate division agrees with the Public Employment Relations Board. It goes to the Court of Appeals, and they say that the Public Employment Relations Board and the appellate division are wrong about this, that what has to be collectively bargained is not an economic benefit per se, it's the terms and conditions of employment. So it has to have some nexus to the actual employment. And this particular kind of fee is unrelated to the employment. In fact, it's about getting another job. There's no nexus between this waiver of fees and either job qualifications or criterion for employment or job-related duties or obligations, nothing like that. And because this is just a Department of New York State assessing fees on everybody, and has nothing to do with their current jobs, it's not a term and condition of employment. And because it's not a term and condition of employment, they didn't have to collectively bargain it. They could just impose it without discussing it with anybody. And so they throw out the ruling by the PERB and the appellate division, and they say that Department of Civil Service can do what they did here, which is assess the fees. That's too long didn't read. Court of Appeals case of State of New York versus New York State PERB, Public Employment Relations Board. If you like what you just saw and you want more of it, please hit like or subscribe to let me know.